this video segment is to help our viewers understand that there are some differences between different mediation processes, and there are differences between different mediation styles. And we're going to discuss some of those. So let's first of all talk about the difference in mediation styles. Basically, there are two different mediation styles. There is what is called a transformational mediator, or a passive mediator is another term that's used. And a passive mediator is one that is not required to be trained in any kind of family law or have an understanding of family law. And the methodology that they use for conducting their type of mediation is also different. They use a process which is called a shuttle mediation process. And so a passive mediator normally requires the parties to have attorneys present. The attorneys put the individual parties in separate rooms, and the mediator then shuttles back and forth between the two parties. And really they act more as a referee and a facilitator and shuttling information back and forth. Thus, they don't have a need to have a firm understanding of any kind of legal concept or financial background, because really they're just communicating back and forth. Attorneys normally prefer this style of mediation. It's 3 times more expensive because you're paying 2 attorneys and a mediator, and the process statistically has about a 55% success rate, according to the statistics that have been published on various court websites. The second kind of mediator is a directive mediator or evaluative mediator. And a directive mediator, kind of like the word sounds, their job is to guide their clients through the maze of divorce. And our style of mediation is more directive. We don't like to have the parties in different rooms. Obviously, if there is some kind of concern that the parties feel like that there's going to be, that they don't feel emotionally safe or physically safe, then of course we make accommodations for that. But if we can, we'd like to have the parties in the room together with the mediator. And a directive mediator is going to act a lot like not only a mediator, but a little bit like a coach. If either of the parties have an expectation that is really out there, then a directive mediator is going to try to give them kind of a gentle reality check. Obviously, both styles of mediation, the mediator is required to be neutral and unbiased. In a directive mediation, they're going to push that limit, meaning they're going to let a party know if they are not bringing to the table in good faith proposals that at least are close to the trends that the courts typically follow, then the mediator's role is to say that is something that's kind of out there and let them know that. It's much better to hear that from the mediator than a mean guy in a black robe. Statistically, our mediations have about a 96% success, which means 4 out of 100 of our cases ever end up needing to go before a judge to be resolved, as we are able to get them through that. The directive style of mediation is much faster and much less expensive because you aren't involving attorneys. Now, people often ask, can I have an attorney in the mediation? Yes, you can. We prefer that the attorneys not be in the mediation room itself in our style of mediation. If you're going to use an attorney, the best time to use them is after we've attempted to put a rough draft together. You take that rough draft to your attorney in a separate meeting, and you can review it with them, and if they have any suggestions they can make, then we'd like that. The reason for that is many times attorneys can actually make the process less collaborative. Remember, attorneys get paid if you argue, and therefore if you argue more, they get paid more. So attorneys are not often as collaborative and working towards trying to get consensus as we would like. And so most of the time, we would prefer that attorneys not be in the mediation process to that extent. There are different types of mediation and different types of mediators. Both of those depend entirely upon what your comfort level is. Within that, it should also be noted that whether or not you have a male or a female mediator, or a male and a female mediator, we always provide the option to a couple if they would like to have both a male and a female mediator part of the mediation process. Because a male mediator has never been a mother, they can be impartial and unbiased. However, they've never walked in the shoes of a mother. So sometimes having another person in the room that has walked in those shoes to co-mediate can be helpful as well. There is another process, another type of mediation that is used when one party is not willing to mediate at all. It's a type of shuttle mediation where you can actually come in, sit down with the mediator. The mediator will attempt to reach out to your spouse, invite them to the mediation, invite them to participate, try to get them to be a part of the process. If they won't, then you and the mediator can put an agreement together. You're going to try to communicate what you believe you think your spouse will think is fair. The mediator will reach out to your spouse again, usually email them a copy of it and say, we wish you would have participated, but you didn't. Here is a copy of your agreement, and if you would like to now come and talk to me about it, there's things you don't like about it, you can visit with the mediator and try to resolve those issues. If they still don't participate, then that mediation agreement can be converted into the necessary legal documentation to be filed at the courthouse, sufficient for a judge to grant a default divorce. Talk to your mediator about that if you're worried that your spouse is just not going to participate in the mediation at all, and they're not going to in any way try to be collaborative, then including even getting an attorney involved. That can be a very effective way to do that.